So at this note, I will be introducing this beautiful young lady, Hannah DeJong. I'm really thankful to her for accepting to speak and sharing her wonderful wealth of knowledge with all of you today. I'm actually really proud of these young lawyers coming in business. I don't know they are happy or not, but I get so excited and happy to see them. Hannah is an associate at Broughton Law in downtown Vancouver, practicing primarily in the area of family law, having successfully representing clients in mediations, case conferences, and trials. Hannah's focus on law is dispute resolution out of court. Hannah brings a special knowledge of innovation and access to justice in law, gained working for the Winkler Institute for Dispute Resolution as a research fellow. So please give a warm hand to Hannah DeJong.
Hello, everyone. I'm so excited to be here to be able to present to you on the topic of family law, which, and I might be a little biased because most of my practice is family law, maybe a little bit of civil. But I think family law is one of the most important areas, and often one of the areas that we see the biggest access to justice problem, because so many people come into contact with the issues of divorce and separation, even if they haven't previously had any contact with the law before. So I'm just going to get my little clicky thing ready here. Oh, that works. Okay. So Baljinder already introduced me, but I work at Broughton Law downtown. I've been practicing law for about 3 years, and I've put my email up there too if you have any questions that we don't have time to answer during this presentation, or if you want to know anything more about family law that you can't find out on the wonderful resources that have already been talked about in the presentation before me online, feel free to shoot me an email or call me, and I'll do my best to answer whatever questions you may have. So here's where I'm planning to go today. I'm going to go through some of the basic elements of family law, starting with parenting, moving on to child support, spousal support, property and debt, and then finally ending it off just talking a little bit about dispute resolution options for clients that have family law issues. And just to start off, I thought that I would do a little bit of an informal survey of the room. So can I get you all to put your hand up if you have a background in family law or you think you're an expert in family law? Just put your hand up. Let me see if there's anyone who feels that way. Okay, a few people, maybe 3 people. And then put your hand up if you have a pretty good knowledge of family law. You know the basics, maybe a little bit more. Anybody? Okay, a few people. And then put your hand up if you know next to nothing about family law. You're not very familiar with it at all. Okay, so this is good. So I'm glad that I'll be going over the basics because it seems like most people don't know very much about this area. So that's good. I have a comic because apparently that's something that you do in a presentation. I've always seen a comic in the presentations that I watch. So I'll just read it out if you can't see. So the husband says in a lawyer's office, "I want half the value of the house and the kids every other weekend." And the wife says, "I want him thrown into a vat of lava filled with special piranha that can live in lava." And I think that the missing A on the word piranha just kind of makes it all the better here. So I put this in just to show that a lot of times people coming in with a family law issue to your office or my office or people in your own lives that you know that experience going through these kinds of issues are really, really suffering. They're really in a vulnerable time in their lives, especially when they are also dealing with perhaps immigration law issues or other issues or emotional issues. They're often experiencing a lot of bitterness and a lot of hurt, and it prevents people from being able sometimes to think the most clearly. I often say that it's helpful for me to remember that people who are coming in that I encounter with the family law issue are often at one of the worst, lowest points of their lives emotionally. And sometimes that can affect their judgment, which is completely understandable given how traumatic of an experience it can be to go through a family breakdown. I also put this up there to show that some people's ideas of what the law is in family is very different than what the law actually is. So I'm hoping what you'll get from this presentation as people who are providing legal information to clients is the ability to sort of gently guide clients who are coming in with very different ideas about what the law is, and probably with good reason, because the laws around family law issues in their own countries are probably very different than the laws we have in Canada. So just being able to sort of guide them into what the law actually is here, so those positions don't get too entrenched, which can lead to more conflict. Okay, so basically I just wanted to give you some initial statistics. So there's a recent cost of justice report that came out that says that 1.2 million people, 1.2 million Canadians will experience a family law problem in any given 3-year period. So it's a lot of people who are experiencing these kinds of problems. I also just want to note that 60% of court matters are family law matters, 60% of matters that judges hear. About 50% of litigants, people who are going to court in family matters in BC, are self-represented. So half of people are going to court trying to navigate our often complex court system without the benefit of legal counsel. So your job is very important in terms of directing people to the right resources outside of court that they can rely on to be able to present their case as effectively as they can. So to start off, the Family Law Act and the Divorce Act applies to people who are spouses in BC. So what is a spouse in BC? Obviously, people who are married, who have entered into a marriage contract. And for unmarried people, you have to be living in a marriage-like relationship for at least 2 years. This is one of the biggest misconceptions I have for people who come into the office who think that it's 5 years until I'm considered a common law, or it's 6 months until I'm considered common law. So it's really, really important to make it clear to people that the period in BC, because it's different in other provinces who have their own family law acts, is 2 years. And knowing that information prevents a situation where people sort of fall into being spouses without actually realizing that they've triggered all of the rights and obligations that come with that. For purposes other than division of property or debt, and we're mostly talking about spousal support here, unmarried people who have lived together for less than 2 years are spouses for only the purpose of spousal support. So if you've lived together with your spouse for less than 2 years, even though you haven't met that 2-year benchmark, you can still seek spousal support if you have a child, okay? Okay, so starting off talking about parenting. So when a separation happens, there's 3 things that parents have to decide. The first is where the children will live. The second is how they're going to make parenting decisions together, which is often a challenge now that they're separated and sometimes don't like each other very much anymore. And how much time each parent will have with the children. So those are the basic things that parents need to talk about. In terms of the language that we use, there's 2 acts that we're concerned about that deal with family law. The first is the Divorce Act, which is a federal act, and that uses the language of custody and access when we talk about parenting. In BC, we have the Family Law Act, which replaced the former Family Relations Act in 2013. So, I mean, it's been around for a while now, but it's still a pretty relatively new act, and it has pretty recent language, up-to-date language around parenting. So instead of custody, the Family Law Act talks about guardianship. Instead of access, the Family Law Act talks about contact. So contact is when you aren't a guardian of a child, but you still spend time with them. So that could be like a grandparent, extended family, aunt and uncle. Parenting time, of course, is the time that parents spend with their children. Parenting responsibilities are the decisions that parents have to make about their children, where they're going to go to school, what kind of religious upbringing they're going to have, the day-to-day parenting decisions of what they're going to eat, things like that. So while both acts do apply to parenting issues, in BC, because the Family Law Act is more recent and robust, that's generally the act that people rely on when they're talking about parenting. We don't really use the terms in BC, because we have the Family Law Act, of custody and access anymore, and I encourage you to also not use those terms, but use the terms that are in the Family Law Act. And the reason for that is because talking about parenting time and guardianship doesn't have as many negative connotations as custody. People talk about custody battles or losing custody or fighting for custody, and none of those connotations are, so far, attached to guardianship and parenting time. I just also want to mention that the Divorce Act is in the process of being overhauled, which is a really good thing because it became law before the internet was invented, so it's a tiny bit out of date. It's 1985, and some of the proposals for overhauling the act actually mirror what our current Family Law Act says. So a lot of the stuff that we're relying on for parenting in BC is going to become federal law in the future, although that hasn't happened yet. It's still in process. Both acts apply. Most people use Family Law Act. But one helpful thing that is in the Divorce Act and that's not in the Family Law Act is the principle of maximum contact. So that basically says that it's best for the child to have as much contact as possible with both parents, whereas the Family Law Act says that no particular parenting plan or arrangement is presumed to be in the best interest of the child. And that's really important because sometimes clients come in and they think, we're separating and I was caring for the children most of the time, so I'm automatically primary parent. No, that's not how it works. Or, a parent who wasn't as involved will think that they're automatically shared parents, it's automatically 50-50. No, the court will look at every situation differently, and will look at the best interests of the particular child in a particular situation to figure out what parenting plan works best for them. So I'd like to take a minute to talk about the best interests of the child, because unlike other areas of law where you're relying on decisions from previous decisions in the court, there's a lot of legalese and legal principles. Parenting is actually one of the easiest areas to navigate because the only principle that matters is the best interests of the child. So when I go to court on a parenting issue, I'm talking about who does this child have a stronger bond with? Who have they spent most time with? What are the different parents' abilities to be able to meet the needs of this child? So often, who's in the best position to do that is your own clients, because they know their own children better than I, better than a judge who's going to be hearing their case, who doesn't really have any of the family history. So I encourage you to help clients put their children's interests first and to try to separate their children's interests from their own interests, because there's a lot of risk of those getting entangled, especially when parties are really emotional when their family is breaking down. So under the new Family Law Act, it states that the court must consider the best interests of the child only. So this is different than the previous Family Relationship Act that I mentioned, because under that act, there was priority given to the best interests of the child. Now it's the only factor. So it's not just the most important thing, it's the only thing that courts will consider in making parenting decisions. So the Family Law Act sets out a number of factors that the court will look at in trying to figure out what actually is in this child's best interest. It's a non-exhaustive list, but it is helpful because it gives you sort of parameters for thinking about what does best interest actually mean. So it includes things like the child's health and emotional well-being, the child's views, unless it would be inappropriate to consider them, And times when it would be inappropriate to consider them are often when the child is way too young. So the court is not going to find the views of a 6-year-old child particularly persuasive. Children have attachment issues. Sometimes they cry when they're going to mom's house or coming back from dad's house, and the court will recognize that this child is way too young for us to take their views into consideration, and really it's best that they spend time with both parents. So that's what we're going to do. The court will also look at the nature and strength of relationships between the child and significant persons in the child's life, the history of the child's care during the marriage. Who was the one doing the day-to-day care of the child? Was there someone who was a stay-at-home mom? Were they sharing parental care of the child? The child's need for stability, given the age and development stage. And younger children, generally, the courts will view them as needing more stability than older school-age children or teenagers. And the ability of each guardian to exercise parental responsibilities. The courts will also consider the impact of family violence against the child or another family member on the child's safety, security, or well-being. So the family violence, if it exists, doesn't have to be directed at the child. It can, if there is family violence between the husband and wife, and the child was present for that, that's a factor that the court will consider in determining what is in their best interests in order to try to reduce the risk that the child will be exposed to family violence again. And of course, if a person responsible for family violence is impaired in their ability to care for the child or meet the child's needs, the court will also take that into consideration. I'm not going to go into a lot of detail about family violence because you guys will be getting another session on that later on. But there is a quite extensive definition of family violence in the Family Law Act. It's not just physical violence, it's sexual, emotional, psychological, financial. It's very comprehensive. So this is still the factors in the best interest of the child. There's a lot of them. So another one is the appropriateness of an arrangement that requires the guardians to cooperate on issues affecting the child and the risks of requiring cooperation. So for example, if the parents aren't able to agree on everything and they're constantly putting the child in the middle of conflict, then the court might say that, you know what, it's actually in this child's best interest to have one parent have the parental responsibilities and give one parent veto power so they're not always having to consult with each other if that's really just not working. And any civil or criminal proceeding related to the child's safety, security, or well-being. So if someone has been arrested for domestic violence, for example, the court would consider that as well. Basically, the bottom line is that any agreement that people enter into about their family law issues or order that the court makes is not in the best interest of the child unless it protects to the greatest extent possible the child's safety, and that means physical, psychological, and emotional. It's really important, and I mentioned this before, but it's so important to be able to get parties to focus on their child and what their child's interests are instead of their own interests, because that's what the court will consider. And honestly, that's just the right frame of mind to have when you're getting separated. So, and hopefully people are really trying to put their children's interests first instead of just framing their child's interests or framing their own interests as their child's interests when they're going to court. But basically, there's a lot of social science research in this area that says it's not divorce and separation that is harmful for children in and of itself. It's actually the conflict that's happening between parents that really harms children. So the more that parents can reduce children's exposure to conflict, the better. Yeah, and that's all I'll say about that. Okay, so now talking about guardianship. So sometimes there's a misconception about guardianship and when someone can become a guardian of a child. So just to clarify, parents living together at the child's birth are automatically guardians. So you don't have to worry, parents don't have to worry about whether they have those rights. Parents can lose their guardianship status by agreement or order. Usually that only happens if a parent has, like royally screwed up, like really, really bad. Even a parent who has perpetuated some form of domestic violence, the court may still value the presence of that person in the child's life to some extent by ordering a supervised parenting arrangement or something like that. But to strip someone of their guardianship status entirely is very difficult. There has to be often a long history of extremely inappropriate behavior towards a child or a complete inability to parent the child properly. Courts do recognize that a child can have more than 2 guardians, usually more guardians when a person, such as a grandparent, is regularly involved in caring for the child is seen as a good thing because it's more people to care and support for the child. And a person other than the child's parent can also be the guardian. It's not just the biological parents. There is potential for people to not automatically be guardians if they're in a situation where they haven't been living together with the child when the child was born. So, for example, we had a situation where people were married and the wife became pregnant and they got separated during the pregnancy. So when the child was born, she was contesting guardianship. But the way to get around that, as you'll see in this slide, is that if you're someone who's regularly caring for the child, then you can still be a guardian for the purposes of this section. So it has to be something that's more than occasional care. So if you're seeing the child once a month, that's probably not enough to fall into the regularly cares category. But even if you didn't live with the child when he or she was born, but you're having parenting time once a week or on some kind of regular basis, then you're probably a guardian also for the purposes of this section. Having guardianship is important because only guardians can have parenting responsibilities. Only guardians get that special decision-making power to make decisions about their children. So as I mentioned a little bit before, parenting responsibilities include those day-to-day, everyday decisions, and usually the parent who has physical care of the child is the one who's making those decisions because that just makes sense. But it also includes bigger decisions. So who the child associates with or who the child has contact with, education and extracurricular activities, cultural, linguistic, religious, and spiritual upbringing, giving consent when consent is required for a minor child, applying for a passport license or other benefit for a child, and generally, regardless of their decision-making power, both guardians will have the ability to get third-party health, education, or other information. So they have the ability to get those notices from the school, to have access to the child's medical records, things like that. And just one more thing I'll share about parenting responsibilities before moving on to parenting time. I'll just go back for a sec. Parenting responsibilities are only afforded to guardians, but that doesn't mean that as a guardian, you automatically have all the parenting responsibilities. In fact, being a guardian doesn't mean you would be allocated any parenting responsibilities. And an example of that is where there's a child who lives with, we had a situation where the child lived with dad in Seattle in the United States, and the mom lived in Vancouver. And dad had all of the parenting responsibilities for making decisions about the child because the mom only saw the child every other weekend. So in that situation, it made sense for the dad to be able to make those bigger decisions and the mom to have the day-to-day decision-making and the access to third-party records when the child was in her care. And this was something the parties agreed to. But it's also along the lines of what a court may order. So parental responsibilities can be allocated or shared among the guardians in a shared parenting situation. Usually both of the parents have all the parenting responsibilities and they have to figure out what they're going to do if they can't agree. So sometimes you'll see clauses where the parents have all the parenting responsibilities, and if they can't agree, one parent has veto power and they can make a decision. Or if they can't agree, the parties might go to mediation and say, we're having a disagreement about what school we want our kid to go to. I think this school is really great. my ex-husband thinks this school is really great. Can you help us make a decision by consensus? And they can do it that way too. Or, of course, go to court if they can't agree even after mediation. In terms of parenting time, I already mentioned that parenting time is something that the Family Law Act doesn't make any presumptions about. But what I want to say as a caveat to that is that in BC, which is a very progressive jurisdiction, often what you see in terms of the practical reality is that courts tend to lean towards shared parenting arrangements along the lines of the Divorce Act, that maximum contact principle that I talked about. So they realize that in many situations, unless there's, a risk of violence or harm, or someone just has no idea to parent a child, and then a gradual schedule leading up to shared parenting may be more appropriate. But in general, it's good for children to have as much time as possible with both parents, and usually that's the arrangement that most closely mirrors what they had when the parents were together as well. So it's important to keep that stability going. Okay, so I've just made, and this is obviously very general, it's not going to work for every family, but in a shared parenting arrangement, usually what works well is to have more transitions with very young children, because it can be difficult for parents to be away from, say, an 18-month-old baby for more than 3 days at a time. So often what we see is a 2-2-3 schedule where parents will transition every 2 or 3 days. By the time children get to school, it's usually appropriate to have a little less transitions and longer parenting times, for example, week on, week off in a shared parenting arrangement, or sometimes parents will do like a Thursday to Tuesday type schedule and alternate that way. It really depends on what works for the parties' work schedules and the children's activities and things like that. For teenagers, you often see extended periods with each parent, or kind of a come and go as you please mentality. I don't have teenagers myself, but I know from being one that it's very difficult to tell a teenager what to do. Sometimes what you see is there is a parenting plan in place, but the child, especially if they're, over the age of like 12 or 13, will make their own decision, and they have the ability to just go to mom's house when they want to, or go spend time with dad when they want to. And the courts are usually pretty deferent to the children's views when they're at that age, more so than they are for, a child who's 6 years old, like I talked about earlier. So the children's views become more important as they get older. All right, now talking about child support. And I'm just going to look at my time here. Oh, I'm okay. Okay. So the important thing to know right off the get-go about child support obligations, and a lot of clients have misconceptions about this, but the obligation to pay child support is completely separate from parenting time. Even if the person who's paying child support never sees the child and has no role in the child's life, that obligation to pay child support still exists, okay? So frequently we have people who come in and say, well, why should I pay child support? I have nothing to do with them anymore. And it's like, no, it's completely unrelated. You have to give some information and sort of help to guide the person into understanding that their child support obligation is not tied to time that they spend with the child or to a relationship with the child. Child support can be payable by non-guardians and step-parents sometimes. It's important to recognize that even though it's paid to the other spouse, it's for the benefit of the child, and it's different from spousal support in that way. So the purpose of it is not to subsidize the other spouse's living, but really to cover the expenses that person is incurring for the child. So in BC, the age of majority is 19. So every child who's under the age of 19, a child of separated or divorced parents, is eligible for child support automatically, okay? And I'll go over different exceptions that apply to children who are above 19 in a minute. But it's an automatic obligation. It's an automatic eligibility. So in Canada, we have the federal child support guidelines. These were created to try to reduce arguments about the amount of child support. So they've been adopted in every province, including BC. And what they are is a set of tables that sets out what amount of child support is payable based on someone's income, how many children they have, and what province the children reside in. So it's a very simple exercise, and I've included a link here. I don't know if it'll work if you get your materials, but if you go to Google and type in child support table lookup, there's a very simple calculator that all you do is put those 3 pieces of information in, and it tells you what the guideline amount of child support is for your income. So it's very easy and simple for people to find out what the child support amount is that they're supposed to be paying. Okay, in terms of child support amount, so normally when you see it payable is when one person has the children most of the time, and then it's a very simple, I have the children. A shared parenting arrangement is anything from above 40% of the time. So if you have the children more than 40% of the time, and the other party has the children at least 40% of the time, you're in a shared parenting arrangement. So sometimes what happens, although it's not always the case, is that parties will calculate each of their child support amounts, and then one party who has the higher income will pay an offset amount to the other party. Sometimes parties, if they have really similar incomes, will just say, we're not going to pay child support to each other because it would essentially just be, $500. It doesn't really make sense. Or it's just, it's like $10 difference between the 2 payments. But if one person has the majority of the parenting time and they're not in a shared parenting arrangement, then they will receive child support only from the other spouse. They won't have an obligation to pay child support if they have the children the majority of the time. Okay? Okay, so types of child support. So there is the regular child support monthly payment, which is based on the 3 things that I mentioned. So that is the regular child support amount that's paid every month. It is non-taxable to the recipient spouse. And the other category of child support is special expenses. So these are categories of expenses that are above and beyond what child support or the person's income would cover. And I'll go through what some of the categories are. So in looking at these, they have to be necessary and reasonable for the party's means. So lower income parties, there may be less things that the court views as reasonable because there's just not enough income to go around. So for example, if you and your ex-spouse have a combined income of $60,000 a year and your child is enrolled in horsebacking 4 days a week, which costs $10,000 a year, the court is not going to view that probably as a reasonable expense that would fall into this category because the parties simply can't afford it. Of course, each parent is able to pay for whatever they want for their own child. If one of those parents in that relationship wants to enroll their child in horseback riding without asking for contribution from the other parent, that's fine. But if you want the other parent to contribute, it has to be necessary and reasonable. So unlike the best interests I talked about, which is an open set of categories, and the court just gives us a list of factors to think about, special expenses is a fixed set of categories. So if you have an expense that you're trying to claim as a special expense that the other spouse contributes to, it has to fall into one of these categories. So it either has to be childcare, medical and dental insurance premiums, out-of-pocket health care over $100. So a frequent one we see for that is, when kids get old enough to have braces, that will fall under that category. Educational expenses, including post-secondary education, and I'll talk about adult children and child support in a minute, and extracurricular activities. In terms of daycare, that will almost always be considered necessary and reasonable, provided that daycare is incurred because one spouse is going to work, or they're doing education or training, or suffering from an illness or disability that prevents them from being able to care for the children themselves. I should also mention that sometimes the needs of the child will outweigh the cost of the expense to the child. And something can qualify as a special expense even if it causes hardship to the parents. So an example of that would be counseling services, which you see a lot of parents enrolling their children in because they're often struggling with dealing with the fact that their parents are in conflict after they're separating. So the court may see that as reasonable and necessary, even though ordinarily the parties may not be able to afford it. Or tutoring services where the child needs some extra help to get through school. Or lessons and coaching in arts and sports where the child has a special talent that should be nurtured. So often it's a misconception that anything I enroll my children in is automatically a special expense if I can afford it, but that's not always the case. The child has to have a special talent in that area. Usually parties are on the same page, especially if their kids are telling them, I really want to go to soccer, and they won't be too hesitant to contribute towards that. But sometimes it can be a point of attention. One parent is really gung-ho about hockey and the other parent doesn't really care and doesn't want to contribute. And you might get into arguments about whether the child has a special ability such that it's appropriate to meet their needs to pay for that expense. So it can get a bit messy. Okay, so I mentioned that I would talk about this. So now we're talking about child support for adult children. So once a child is 19, they are above the age of majority, above or at the age of majority, and child support is no longer automatic for that child, okay? So if a parent still wants to seek child support after their kid has turned 19, the onus is on them, basically the burden is on them to say why that should be the case, okay? So in order for child support to be payable for an adult child, they have to be, for one reason or another, unable to withdraw from their parents' charge. Common reasons that we see for that, one we just had recently, we had a 24-year-old adult child who was disabled. In that situation, if the child is unable to work or unable to support themselves or live on their own, then you could see child support being payable for longer than just 19, and potentially for the rest of the child's life if they're really struggling. Or if the child is attending university or college. So in those situations, generally, the court will allow an adult child to benefit from child support for one program of post-secondary study, which means one degree or diploma, so long as the child is enrolled full-time. So if a child is going for their undergrad and then their master's and then their doctorate and their postdoc, the court isn't going to impose a child support obligation for all of those degrees, just generally the first one. And I mentioned before that the child support amount is very easy to calculate online for a child who are under 19, but if children are older than 19, it's not necessarily that really clear table amount. It can be a different amount depending on the child's needs, means, circumstances. So for example, if the child is getting a lot of financial aid for their post-secondary education, or if they're working part-time and they're contributing to their own expenses, then that might be an argument to say that child support should actually be less than the guideline amount because the child is able, at least a little bit, to contribute to their own expenses. And I'm just gonna take a second to check my time again. Okay, looks like we're still good. Oh, and I should have mentioned this at the beginning, but there's a lot of information here, and I know that it can be a lot to take in, but I will try to leave a generous amount of time at the end for questions if anyone has them. And I think Baljinder mentioned we have these 3 microphones that are set up. So please speak into those for the purposes of getting your questions captured for the webcasting. Or if you don't want to line up or you're unable to, you can put up your hand and just say the question, and then I'll repeat it into the microphone so that everybody can hear it. Okay, so moving on to spousal support. So when we're talking about child support and spousal support, and parties are a very limited means, which may be some of the clients that you come into contact with, it's important to know that child support takes priority over spousal support. So for example, even if someone is entitled to both spousal support and child support, but the parties are low income, it may be the case that there's simply not enough money to go around to meet both the spousal support and child support obligations. So in some scenarios, we see only child support being paid, even though the person has a strong entitlement to spousal support as well, because that's what the family can afford. And I also just want to mention that this is often one of the hardest pills for clients to swallow when they come in my office, the idea that they have to make monthly payments to their ex-spouse for their support is not something that people are super excited about. But it's important to remind people that the way that they structure their roles and responsibilities during the marriage can often mean that one person is in a way better position to earn income to support themselves after the relationship ends than the other person. So a situation that we often see is somebody who left the workforce in order to care for the children, and it's often the wife. Meanwhile, husband is going off and developing his career and making advancements and getting raises, and the wife's career is basically forestalled because they've made a decision together as a couple that she'll stay home with the kids, and it's not fair that when a relationship ends, that the wife should be in a position where she doesn't have any support because of decisions that were made during the relationship. So unlike child support, spousal support is not automatic. You have to prove that you're entitled to it, and you have to meet the definition of a spouse in order to seek spousal support. So remember I mentioned that 2-year period that you have to be living in a marriage-like relationship in order to be spouses. So if you have been living together for less than 2 years, you're not entitled to spousal support, but the exception is if you have a child together. The objectives of spousal support are set out in the Divorce Act. So this is what we're hoping spousal support is going to achieve for people. We're hoping that it will recognize the financial advantages and disadvantages that a spouse will face from the relationship or separation, that it will reduce economic hardship. So that's basically saying that it will allow each spouse to be able to meet their financial needs, share the financial burden of consequences to caring for the children during the relationship. So this is one that comes into play a lot when people have been living together for less than 2 years, but they have a child, and to help spouses be financially independent. Spousal support is very important for people because as anyone who is divorced or knows someone who's going through divorce may know, 2 households are a lot more expensive to run than one. And parties who are separating are often facing a large financial burden of paying an additional rent, furnishing their house with additional furniture, and only being able to survive on one income. So spousal support is very important to ensure that people aren't just left in the lurch financially after a separation. So there's 3 bases for entitlement to spousal support. First I'll talk about contractual. So spouses have agreed that spousal support is payable, and you might see this in a marriage agreement, like a prenup, or a cohabitation agreement, or a separation agreement that sets out this amount of spousal support will be payable if we separate, or we have separated and we have agreed that spousal support will be this. But most people, I would say, don't have these agreements in place, so the entitlement basis that they're going to be relying on are needs-based or compensatory. So needs-based is when a spouse has financial need. They simply have expenses that are higher than their ability to meet that need, and the other spouse has a higher income and they're able to pay spousal support to meet the need. And compensatory is where it's a little bit trickier because you don't just look at the spouse's financial situation right after separation. You actually have to look back over the history of the relationship. So compensatory is when a spouse suffered an economic loss or hardship as a result of the relationship or breakdown. So a situation that would fall into that is the one I talked about before, where mom stayed at home watching the kids. She didn't advance her career, and dad was able to do that. Sometimes we see a situation where the other spouse gained an advantage to the detriment of the other spouse's career. So, for example, that could mean you're married and you're working and you're helping to put your spouse through school, and now they have a medical degree, and maybe you weren't able to advance your career as much because a lot of your income was going to support them and their tuition. So with the compensatory basis, it can be a little bit harder to prove exactly all the ins and outs of what went on during the spouse's relationship, who was actually at home caring for the kids. So we see a lot of that come out in detailed affidavit evidence, but it's often contested. Someone will say, we both decided that I was going to stay home and care for the kids. And then the other person will say, no, I was always pushing her to go and find a job, and she just didn't want to. She's lazy or whatever. So it's sometimes hard to prove a compensatory basis to spousal support. But the good news is that in the interim, before trial, courts are generally willing to order spousal support even when a spouse can't necessarily prove exactly all of the elements of it, or even where there's a lot of conflicting evidence, because they want people to be in a position where they're supported before the matter gets resolved, which can often take a really long time. It can take, up to a year to set a trial date, and if someone is not receiving spousal support for that entire period, it can be very difficult for them to manage their own affairs, much less afford a lawyer to help them resolve their dispute. So that's entitlement. So talking about amount and duration. So there are certain factors the court will look at. They'll look at the length of time the spouses were together, the role that each spouse played in the relationship, and if there's an order or agreement for spousal support. So determining the amount of spousal support is very different than determining the amount of child support. Child support, you go to the guidelines, you punch in the information, it spits out a number, that's your child support. Spousal support calculations are a little more tricky. There is a service online, mysupportcalculator.ca, where you can direct clients to help them get a very rough spousal support calculation. But generally, you need a special software to provide accurate numbers for spousal support, because there's so many factors that you put in to the calculation. So you put in the age, you put in the length of the relationship, you put in the incomes of the parties, you put in the special expenses that are being paid. There's a lot of factors that it's a very complex calculation, and there's a lot of factors that you need to put in order to get an accurate result. But generally, there's the calculation software that we use will put out a range of numbers and will give a sense of a duration. So usually there's a low range, a high range, and a mid-range. Parties, when they're negotiating, generally tend to go with the mid-range because it's just easier to pick a middle amount to agree on. It sometimes helps reduce conflict to go with that amount. But someone may have a ground to claim the high range of spousal support if they were particularly disadvantaged in the marriage. So, for example, if they were caring for a disabled child during the marriage, we just had this situation, and they weren't able to work at all, then they may say, I'm entitled to the high range of spousal support because that is appropriate to compensate me for the disadvantages that I suffered because of the relationship. Okay? It's possible to, similar to child support, although I didn't mention this before, it's possible to change an order or an agreement for spousal support if there has been a material change of circumstances that didn't exist when the order or agreement was made. So material change of circumstances is a legal term, but generally for spousal support, what you often see people arguing is, so for recipients, they may say they want to change spousal support if spousal support payments are going to end. They were only set for 5 years, and the end date is coming up, but their financial situation hasn't improved, or if their financial situation has actually gotten worse, and they need more support than they did before. Or if something unexpected happened, like they became ill, they maybe got in a car crash and they can't work anymore, then they may argue for spousal support to be extended or reviewed so that they can continue to be supported. The purpose of spousal support is for spouses to become self-sufficient. Often, I mean, sometimes that's not always possible if things happen that you can't expect, but it's important for people who are receiving spousal support to know that this isn't just a supplement to their income that they can live off forever. They still have a duty, because they're no longer in a relationship, to go out and get retrained, maybe, seek more education if that's appropriate, but try to re-enter the workforce, even though it is difficult sometimes for people. But they do have an obligation to try to become self-sufficient, and the court will look at whether someone is trying to become self-sufficient in ordering spousal support. So are they applying for jobs? Are they updating their resume? Are they trying to get skills so that they can get to a place where they don't need to be supported forever? Okay, so as you can see, I mean, there's a lot more I could say about each different topic, but I'm trying to give just a general overview. So I'm sure that you'll have lots of questions, but I feel like I'm going really fast. But anyways, this is the last substantive part that I'm going to talk about for family law before moving on to talking about dispute resolution, actual options for people to try to resolve their family law problems. Okay. So property and debt is different than all of the other areas because you have to be a spouse in order to be entitled to property and debt division under the Family Law Act, and there are no exceptions. So if you're under that 2-year mark, you are not entitled to property and debt division. One thing I should mention about the 2 years is that for married spouses, the date that your property becomes family property is not actually the date that you are married. It's the date that you started living together. That's a common misconception among people. And for cohabiting couples, once you have been living together for 2 years, the 2-year period kicks back to the start of your relationship when you started living together. So it doesn't just start from the time that you've been living together for 2 years. Once you hit that 2-year mark, the 2 years before that is considered the start of your relationship. Does that make sense? Okay. Sorry, okay, so yes, I'll repeat. So if you have been living with someone for 2 years, once you hit that 2-year mark, the start date of your relationship is when you first started living together. So for example, if I hit the 2-year mark if I start living with someone today, April 10, and then April 2021, I hit that 2-year mark, the start date of my relationship is April 10. So that today would be the start of my relationship. So that's the relevant date for property division. Some people aren't aware of that. They think the 2 years starts from when they've hit the 2-year mark and goes on from there. Okay, so I've talked about the date that starts the relationship, and now in terms of the end date of the relationship, the triggering event is the separation date. So once you hit separation, that means that each spouse automatically has an interest in everything that is family property. And I'll talk about what is family property later on, but that is the date that triggers the right to property division. And I should also mention that the Divorce Act doesn't talk at all about property division, so these claims are only going to be made under the Family Law Act. So you don't have to worry about the Divorce Act at all here. or telling clients about it for this issue. And I should also mention too, with cohabiting couples, sometimes it can be a little bit difficult to determine when people actually started living together. Sometimes, someone is spending every night at someone else's house, but they still have their own residence, or they've moved some of their stuff there, but they aren't really living there yet. Or sometimes parties are actually in a marriage-like relationship, even though they have separate residences, because perhaps they live in different cities just for practical reasons or for immigration reasons. So I can tell you that entire trials have been fought on when the relationship started. And there's a series of factors the court will look at. Did they share finances? Did they spend holidays together? Did they vacation together? Did they tell other people they were a couple? Were they planning on getting married? Were they engaged? So it can be a very complicated issue. So if you have someone in that situation where it's not clear whether they're common law or not, you just may want to advise them that that they may be a couple. They may still be in a marriage-like relationship, even if they're not living together, if they're meeting some of those factors. Okay. So that was a little bit of a side note. Limitation periods are very, very important in property division. So I'm not sure everyone knows what a limitation period is, but basically that means that it's a period that once it expires, you can no longer make a claim to court for that relief, okay? So the limitation period for property division in BC is 2 years for married spouses from the date of divorce. And to be honest, that's not really so much of an issue because divorce is often the last thing that happens in a family law dispute. After the other issues are settled, the parties will go to court and get a divorce, and it's usually not a very contentious thing. So the limitation period usually is not a big concern there. But for cohabiting couples, the limitation period for bringing a property claim is 2 years from the date of separation. So as soon as cohabiting couples who are spouses separate, the clock starts ticking. So it's really important if you have clients who come in who are thinking they may be entitled to some property division and nothing has really happened since separation, and it's been maybe a year and a half since separation, you really want to inform them of the fact that there are limitation periods, and if they can't agree, they're not going to be able to go to court if that 2-year period expires. Having said that, there is one thing that can suspend the running of the clock, so to say, the limitation period, and that is if parties are actively engaged with a family dispute resolution professional. So if they have a lawyer and they're trying to work out their differences, or if they're going to mediation, they're not simply just sitting on their hands, then that is potentially something that could stop the clock so that it keeps their claim alive for longer than the regular 2 years. Okay, so family property. Family property is a very, very broad definition. So generally it includes all property that's owned by either party at the date of separation, including assets acquired after the date of separation with family property. So for example, if I separate from my spouse, we have a joint bank account, I take funds out of the joint bank account and buy myself a brand new Corvette because I'm having a midlife crisis, that is family property because it was bought with family property. Oh, I'll also mention, so it includes real property like houses, the family home, personal property, which could be furniture if it's expensive furniture, art, jewelry, things like that, things in a safety deposit box, corporate interests, ventures and partnerships, bank accounts, investments, RSPs, and pensions, including the Canada Pension Plan. And then I'll talk about the piece about excluded property later when I get to that. Family debt is all debt incurred by a spouse during the spousal relationship. So if I was going to school before I started living with my partner and I incurred a lot of student loans, that is my own personal debt because it's debt that I brought into the relationship. So only debt that was incurred during the relationship is going to be split between the parties. It also includes debt incurred after separation to maintain family property. So if one spouse was making mortgage payments or had other debts that came due on a line of credit, for example, that they were paying for the kids or the utilities of the house or something after separation, then that would still be family debt because it's used for the benefit of the family. So I mentioned that everything owned by the spouses at the date of separation is family property. This is the exception to that. So excluded property is all property the spouse owns when the relationship started. So if I'm getting into a relationship and I already own my own condo, then that is my excluded property because I brought it into the relationship. The thing to remember with this is that the value of the excluded property when we started living together is excluded, but the increase in value throughout the relationship is not excluded. So it can get a little bit complicated, but for example, if I am getting into a relationship, I have a condo, my condo is worth, I was going to say $100,000, but that doesn't really make sense. My condo is worth $500,000, and we were in a relationship for 5 years. 5 years from now, my condo is worth $800,000. So that $300,000 is family property because it's the amount that my property increased. Okay?
So even if there is a premarital agreement that condo always belongs to me, it doesn't make sense.
I'm just telling you, there's a lot of mumbling going on. I'm just telling you what the law is under the Family Law Act. So this would apply to people who don't have an agreement. If people have a cohab agreement or a marriage agreement, of course you can agree to basically anything you want to that is different than this act. But if people do not have that, this is what the scheme that's going to apply to them. Often we do cohab agreements for people or marriage agreements where they say, I have my property, I'm bringing it into the relationship, and we want to agree that even the increase in value is still my own property if we ever separate, and that's totally fine. We do that all the time. But that's not what the family law default mechanism is. Okay. So other things, so in addition to property you brought into the relationship, other things that are excluded property are gifts, not gifts from your spouse, but gifts from third parties, inheritances, court awards, so if you get a court settlement award for some amount that's unrelated, like an insurance claim or something, or a personal injury claim, insurance payments, and property held in a trust that was contributed by someone else. Those are all things that you can claim as excluded. Now, excluded property isn't just automatic in BC. In some provinces, like Ontario, it is. Everything that you owned before the relationship is automatically your own property. But in BC, you have to make the argument that I had this before marriage, and I have documents to show that I bought this house in 5 years before we got married. So the burden is on you, the person who's claiming the property is excluded, to prove that you had it before marriage or to prove that it was your inheritance or something like that. Okay, so that kind of ends the substantive portion of my talk. I know that was probably a little bit confusing, maybe for some people, and a lot of information. But this section of what I'm going to talk about is equally, if not more important, dispute resolution. So just to start off, this is why talking about dispute resolution is so important. So again, going back to the cost of justice report, this is a report just from 2018, so just last year. $10,000 and 98 is the average that's spent on trying to solve legal problems by people who appeared in court. And half of that amount, about $5,500, is the average people spend on legal problems by people who did not appear in court. So going to court is very, very expensive. especially if you have counsel. This report also had numbers on differences in costs of resolving disputes where people were represented by a lawyer and where they were not. And it's similar to these numbers. It's about $10,000 as opposed to $5,000 if someone has a lawyer versus someone who doesn't have a lawyer. And the reason I bring that up is just to say that it's very, very important to inform people that it's not appropriate to automatically go to court to resolve their disputes. It can often increase conflict and kind of derail the whole process. Family court is in the same courthouse. It's the same court system that people use for their other matters. It's the same court system that we have for insurance claims, for IP matters, for personal injury. There isn't a special family court system that operates differently. So it is a very adversarial system with one person on one side arguing one thing, another person on the other side arguing something opposite. And going there can sometimes fuel the fire between parties who are already in conflict. So it's really important that people try whatever out-of-court options are available to them and only use court as a last resort if they really just can't agree. In the Family Law Act, one great thing that we're seeing is a huge emphasis on support for dispute resolution processes outside of court. The government, the courts, lawyers, everybody is pushing for more dispute resolution outside of court in the area of family law. An important thing to remind clients of is that even if they're not in court, they still have a duty to make full and frank disclosure. Disclosure is often a huge hurdle to getting things resolved, so much so that courts have actually called it the cancer of matrimonial litigation. Someone could be not forthcoming about their assets or hiding assets in other countries, or they're saying, I'm only making $10,000 a year, but really they're earning money under the table from whatever. So it's really a big barrier to getting things resolved in a timely and efficient manner. And just because parties aren't in court, they need to know that they have the same obligations to make disclosure as parties that are in court. There's also a lot of support for agreements, especially agreements on property and spousal support. The only way to get an agreement set aside is to prove that it's significantly unfair. Under the Family Relations Act, the old act that we had before, all you had to do was prove that it was unfair. And to, normal, non-legal people, the difference between significantly unfair and unfair might not really seem that important, but in legal terms, it's really, really important because it places a much higher burden on the person seeking to set an agreement aside, and it makes agreements that parties enter into more protected, which is a good thing because we want people to be able to rely on agreements that they make, on arrangements that they choose to make that are different from what the Family Law Act provides. So here I've set out some dispute resolution options for people, and I won't go into each of them in very much detail. There are people who do whole presentations on out-of-court dispute resolution options. But generally, the first one is always negotiation. And this can be done with lawyers or without lawyers. Often parties who are pretty amicable, who maybe didn't have a super emotional separation or a super high conflict separation, can work things out between them just by talking to each other, just by sitting down and having a coffee and maybe even having a neutral third party, like a mutual friend there to try to help move things along without things getting too emotional. We always encourage parties, as soon as I get a client, I always make sure to let them know, to give them some communication guidelines for communicating with their ex-spouse, such as make sure all your communication is very businesslike. Just talk about matters that involve your children. You don't really need to talk about anything else. If you're already in court on other issues, for example, Don't send an email when you're in the heat of the moment and you're angry, maybe sleep on it. Just kind of common sense stuff so that you can ensure that communication between people is as productive as possible. Mediation is a tool that we use in almost every case we have. In the Supreme Court process, you can actually compel parties to go to mediation by serving them with a notice to mediate. But a lot of people just choose to attend mediation because it's a much more cost-effective way of trying to resolve disputes than going to court and having lawyers. So basically that's it's a structured session with a trained neutral third party who helps facilitate discussions that parties have and helps them try to reach a consensus on their issues. So one of the benefits to mediation is that people have complete control of what they're agreeing to instead of going to court and having no idea what a judge may order. You're completely in the hands of the court, and they may order something that you don't like. In a mediation, you retain agency over the decisions that you're making in your family law matter. A mediator cannot order you to do anything. They can only help you enter into arrangement where you both agree. I often find that parties who enter into mediated agreements are much more likely to follow those agreements than if they haven't been an active role and participate in making those decisions. So it makes agreements stronger as well. Sometimes it doesn't always work. And sometimes in a case, there are issues that are much more contentious than other issues. For example, the parties may not really have a lot to argue about when it comes to property division, but when it comes to parenting, they're completely opposed, and that kind of sets the smoke signals up right away when you start talking about those issues. So sometimes mediation is used just to help parties resolve some of the less contentious issues, and it takes some issues off the table before going to court, which is a really good thing because the less issues that are in play in the courtroom, the cheaper and more efficiently people can resolve their disputes. So they're kind of ranked from least to most intensive. So moving sort of left to right, the next one is mediation-arbitration. So that is when people will start off with a mediator who will try to get them to reach a consensus. And if that fails, then the mediator takes off their mediator hat, puts on an arbitrator hat, and is then in a position to make a binding decision on the parties. So they have a similar role to a judge, but it's still an out-of-court process. Parties will hire an arbitrator and enter into a contract with them that sets out the terms of how they're going to resolve the dispute. So parties could agree that we want lawyers to make submissions, we want to be able to cross-examine each other, or they could agree to a different process. But the difference between arbitration and mediation is that an arbitrator can make binding decisions. One reason why people use arbitration is that in light of the long wait for trial dates, it's often a faster way to resolve disputes, and people have a little more control over what the process looks like, whereas if you go to court, it's always the same process for everybody. It's very, very popular in Alberta and Ontario. It's not used as much in BC, but it's gaining popularity, and it's still a really good option for people and often ends up being a lot cheaper as well. Collaborative law is a relatively new process where parties are each represented by a lawyer, and the lawyers do most of the negotiating. But the key element of collaborative law is that both parties sign a contract that if they want to go to court, they have to get a new lawyer. So it's a process that takes place entirely by negotiation, sometimes with the use of other professionals like mental health professionals, accountants, if it's a complex financial file, things like that. But that's kind of the carrot that collaborative law tries to get people with, is that you have to get brand new counsel who's not familiar with the file and go through that whole process again if you want to take this matter to court. And then, of course, litigation is always open to people, and it is a useful tool and sometimes necessary to resolve a dispute. But wherever possible, we always say to people that it's so important to try all the other options that are available to you to resolve the dispute, and there are so many short of going to court, and using it really as a last resort instead of all of a sudden jumping on the wagon, filing your application the day after separation, which can really just make things go off the rails. I've seen it time and time again. I was very happy to hear in the first presentation we had, a couple people mentioned that their organization offers unbundled legal services. So I'd just like to put in a special word about that. So this is a type of dispute resolution where lawyers are involved, but a lawyer is only involved for part of the dispute. And it's usually the part that the client has the most difficulty with, maybe the one that involves the most legal analysis that isn't really straightforward. Like the representative from Material Women's Center was talking about helping someone who had an evidentiary issue, that there was a lot of legalese and they didn't really know how to navigate it. That is a perfect example of an unbundled service. I provide unbundled services. Not all lawyers do, but it's really important to inform clients that if they're thinking about hiring a lawyer, this is something they should be asking for if they have limited income. So I always make sure to ask clients right from the get-go in the initial consult, what is your budget for legal fees? Because some people are only have a certain amount to spend on legal fees. Some people are only willing to spend a certain amount on legal fees and they're not comfortable with anything higher than that. And for people whom that amount is lower, a full representation lawyer is not going to help them. They're going to review all their documents, maybe attend a mediation, and then the client will run out of money and they won't have gotten much value out of that. So, I'm moving ahead of myself. So with unbundled services, some of the things that lawyers often provide, and that I provide a lot in my own practice, are drafting court documents, so drafting notice of family claim. If the parties aren't in court yet, sometimes drafting a lawyer to the other party, or drafting a letter to the other party or the other lawyer, setting out what that client wants, what their position is. Sometimes we have more of a legal consulting arrangement where the client is in court, they're doing things by themselves, but sometimes they have questions. The other lawyer sends them a letter and they have no idea how to respond. So they'll just send me an email or call me and I can help them navigate that situation. Sometimes it's giving advice on how to present yourself in court, when to stand up, when to sit down, how to refer to the judge, what to bring to court, what to provide to the other party. Services like that are really, really helpful for people who can't afford to fully retain a lawyer. So it's important, and not everyone knows this, but it's not just black or white. Either you have a lawyer who does everything or you are all on your own. There is an option to enter into these unbundled or limited service retainer agreements so that you can just get help for the things that you really need. There's a new website from the People's Law Society called unbundlinglaw.ca. It's very new. It just came out within the past couple months, and it includes a roster of lawyers who provide these services in family law. So if you have someone who is looking to hire a lawyer but has maybe a more limited budget but doesn't qualify for legal aid, they're kind of in that weird middle ground where there isn't really a service that, like a free service that can help them, then I really encourage you to check out the family law roster. There's dozens, if not hundreds, of lawyers on there. You can find one in your area or in the client's area that you can make a referral to. Okay, so that's it for my presentation, and I have a few minutes left, so I'm just going to take 5 minutes to quickly point you towards some family law resources, and then I'll open it up for questions. I'm very aware of the fact that I'm right before lunch, and people are probably hungry and wanting to get some food in their bodies, so I'll finish up here. So Legal Aid has a lot of great family law resources available for you. They have a family law website, familylaw.lss.bc.ca. There's over 900 pages of family law information. A lot of what I've used in my presentation is actually from the Click Law, from my own experience, of course, but also from the Click Law Wikibooks website, JP Boyd on family law, because the information is just so detailed, so beautifully laid out, and in plain language so that anyone can understand it. And this website also has a ton of information that you can use to direct clients to or to answer your own questions about family law. There's also the family law line, as was already mentioned. And then I just wanted to point you to some hard copy resources. A lot of these are outside. I couldn't find an English copy of this. It might be that people took them all, which is great. But this is the Live Safe End Abuse pamphlet. I personally give this to clients all the time who are at risk of family violence. It includes a lot of great information about safety planning, about protection orders, about what your rights are in family law matters, about the criminal court process. So that's a great resource. This is another one, Family Law in BC, and this is a really great, basic, quick, flashcard style resource about just basic family law. So a lot of what I went over in the beginning of my presentation. So someone who has no idea or no reference point for what family law is, this is a really great starting point. It's not an overwhelming amount of information. There's also a pamphlet for unbundled legal services. Another great resource for domestic violence is Mothers Leaving Abusive Partners, especially, geared towards women. I always give clients this resource, Separation Agreements, Your Right to Fairness. If they're not in court and they're trying to negotiate with their spouse, but they're not really sure what they should put in an agreement or how to structure that, or even what issues to think about. And the last one is Coping with Separation. So this is a really great resource to give to people who have just separated or maybe in a state of emotional and financial turmoil, and they're trying to figure out how to navigate that with their kids. So it's really for people who have recently separated and are experiencing a lot of stress. Okay, so I think I have, let me see here. Yeah, okay, so we have about 10 minutes left for questions. So if you have any, I encourage you to go up to the microphone and I'll do my best to answer as well as I can. And if there aren't any questions, I'd be interested to hear from you what kinds of family issues you usually encounter in your work. What are some issues that come up time and time again? Or what are some questions people have for you that maybe you struggle with answering?
Hannah, I do have one question from the audience here, if you don't mind if I start with that. It's just a general question, I think, about accessing lawyers.
Sure.
Do people generally have like their own personal lawyer, like you might have a family doctor? And if so, what are the advantages of that? And do people pay a monthly fee to retain them? Or how does it usually work in general with lawyers and hiring a lawyer?
Sure, yeah, I can answer that. So people will each person will have their own lawyer in a family law dispute. It's a conflict of interest almost in every situation for a lawyer to represent both people. It's just a recipe for disaster because often people's interests are completely opposed. So if someone wants to get a lawyer, usually what they'll do is if they haven't gotten a referral from a community organization, they'll try to find a lawyer online. Maybe they have a friend who used this lawyer in the past. There's all different ways that people find lawyers, sometimes just by Googling different law firms that practice family law in their area. So what happens first is people will have first contact with the firm, and the firm will have to run a conflict check to make sure that they're not representing the spouse already or someone who may pose a conflict. And if there is a conflict, the firm will have to decline representation and point them somewhere else. If there's not, the person will come in for an initial consult. So that's a meeting. It's usually about half an hour or an hour where the lawyer will get a sense of what the issues are, and the client will be able to tell the lawyer what they want to achieve, what they're hoping to resolve. In terms of retainer, Most lawyers and unbundled service arrangements are a little bit different. Those can involve flat fees, sometimes monthly payments. There's a lot of creative fee arrangements in that area, but generally a lawyer will first take a retainer and pay their monthly bills out of that retainer amount. So that retainer amount isn't a flat fee, it's the amount that the lawyer, the law firm keeps in trust, and it acts as their security for legal fees once the monthly bills come due. And if the retainer amount runs out, they'll probably ask for the client to replenish the retainer so that they can keep funds in trust for the monthly bills to be paid out of. I hope that answers the question. Any other questions?
So this is a case like client who met somebody online, and so she got pregnant, and then the guy decided to abandon her. So case like this, is she able to get child support money?
Mm-hmm.
Yeah.
Yeah, I mean, I can't really like give too specific legal advice without knowing the whole situation, but yes, she would be entitled to child support in that situation. Children are always entitled to seek support, parents are always entitled to seek support for their children from the biological parent or even possibly step-parents. So she would definitely have that option open to her. But she would have to, one barrier to her seeking child support would potentially be finding him if she doesn't know where he is or how to contact him or what his income is. Sometimes when there's not a lot of contact between one parent and the other parent that they're seeking child support from, and you're in a situation where you're not sure what that person's income is, sometimes the court will impute income to someone. So even if someone is hard to find or hard to track down, or they're not disclosing any financial information, the court will say, you're a capable and working person. We're going to at least impute a minimum wage to you, and then you can pay child support out of that amount.
The separation period counts from the date if one of the couple or the partner have decided to move out, or the separation could count and they still living together for some reason?
That's a really good question. Thank you for asking that. So the question was, does the separation period start when one spouse moves out, or is it possible that people could still be living together but separated? Is that the question? Okay. So the date of separation, the legal definition of that is the date when one spouse had an intention to permanently end the relationship. Okay? So when parties are still living together, it is possible to be separated. And honestly, in Vancouver, we're starting to see it more and more, where people remain living in the same house even though they're separated because the cost of living is so expensive. It just makes sense. Okay, so in those situations, usually what I tell people, if they're wanting to separate but they're wanting to stay living in the same house, is to make it really, really clear to the other party that they want to permanently end the relationship, or there could be an argument about that later. So you may want to tell people, like, it might be a good idea, or you can't give legal advice, but generally it's a good idea to email the other person or send a letter or something in writing that says, I want to end this relationship. Or the person might say, no, we're not separated, we're still living together, even years later, because sometimes people end up living together while separated for a long time after the initial separation. So the only issue with that is to make it very clear when the separation happened. Hi.
How much a separation or divorce can affect somebody's immigration status? Like when somebody comes to Canada on on family class or spousal class, and
Right.
and then decide to divorce or separate from partner,
Mm-hmm.
what happens to the immigration status?
Yeah, okay, so the question was, how does separation or divorce affect someone's immigration status? For example, somebody who comes here on a family visa, like a spousal sponsorship. So I can't speak in much detail about that. I don't have a lot of familiarity with immigration law issues, but I can say that we are seeing a trend where courts will I think it's starting with the new Liberal government, we're seeing trends where they're not as willing to let people back out of sponsorship agreements they've entered into. So if people are in a spousal relationship and one spouse is sponsoring the other spouse to come over from another country, sometimes we see them still being held to those agreements. Or, for example, we had a situation where one client was trying to seek a termination of spousal support, where the relationship had been very, very short. Ordinarily, he probably would have been able to get a termination of spousal support. But because the court saw that he had entered into a sponsorship agreement to support his ex-spouse, they refused to terminate spousal support because he had basically pledged to support her when she came to Canada. So it's not a very detailed answer to your question, but I mean, generally we see those agreements still upheld, even where people have separated.
There is a session on immigration law tomorrow.
Okay, great. Maybe, yeah, that person may know better than I do.
I have two questions. So one, so does it matter about when they start separated versus when they can actually file a divorce? Is there any time?
Good question. So the question was, does it matter when people are separated, when people have separated in terms of when they can file for divorce? So I didn't talk about the process of actually getting a divorce very much in this application, or in this presentation, but it's a very important question, so thank you for asking. And in Canada, we have what's called a no-fault divorce system. So that means you can get a divorce if you've been separated for 1 year. And it doesn't have to be anyone's fault. There doesn't have to be someone who committed adultery or someone who was abusive. You can just get a divorce if you simply don't want to be married to that person anymore. And it might sound like an obvious thing, but it didn't always used to be that way in Canada, and it's still not that way in a lot of other countries. For example, in China, there is a fault-based divorce system. We work with a lot of Asian clients, which means that you can only seek a divorce if someone is at fault, so someone has committed adultery, for example. In Canada, it's not like that. But to answer your question, you can only ask the court for a divorce, and you have to ask the court for a divorce. A judge has to grant the divorce if you have been separated for at least a year. You can start the process of applying for a divorce before that, but a judge will not grant a divorce order unless a year has passed since the date of separation.
And second question, so if the couple, for some reason, they don't want to spend too much money, like you said about the unbundled
Yeah.
services, what are the simplest way? Like, you said both parties have to have a lawyer. So if they agreed on everything, what is the simplest way? Like they just go to their lawyer, read out like set up all the division on child support or whatever.
Yeah, I think I understand. Okay, so the question was, where parties don't have a lot of money, what is the simplest way to resolve their dispute? So I just want to clarify one thing in what you said. Parties do not have to have a lawyer to resolve their family law disputes. They can resolve their family disputes completely without lawyers. I personally am divorced and resolved my dispute without a lawyer. This is before I was a lawyer. And, but I know obviously it's not as easy for people who don't have legal knowledge, but it is, there's no requirement that you have a lawyer to resolve these kind of disputes. There's no requirement to have a lawyer to go to court. Like I said before, half of people in family court are self-representing. To touch on something else that you said, if you have a situation where you and your partner have separated, but you've agreed on everything, you've agreed on how you're going to parent your children, you've agreed on amounts for child support, you've agreed on how you're going to divide all your property, it's a really good idea to go to a lawyer to get an agreement drafted, because agreements are really, really important. And if they aren't drafted properly, and if they're not drafted with the benefit of legal advice, there's a much higher risk that they can get set aside later, which is a problem because people are relying on what they agreed to without knowing that it might be set aside. Okay? Yeah. I think do we have time for one more? Or I'm not sure. If you want to cut it off, that's fine too. There's one more in the back. Okay, let's take that as the last one. I know people are wanting to eat. Hi. Mm-hmm. Yeah, so that's a really good question. The question was, is there a time period for filing for spousal support? So the answer is sort of yes and no. So under the Family Law Act, the same limitations that I talked about with property division apply for spousal support, okay? You have to apply within 2 years of getting divorced, or if you're common law, within 2 years of getting separated. But if you're married under the Divorce Act, there is no limitation period for spousal support. Of course, as you'll remember, the Divorce Act only applies to married spouses, so that's not open for common law spouses. But if you're married, there's no time limit. We just had a case where someone was applying for spousal support 15 years after they separated, where they were married. But I will say with that is that it's more difficult to get an order for spousal support the more time has passed. So I would encourage clients to go as soon as they can, because their claim could be prejudiced if they wait a long time. Okay? All right, that's it for me. Thanks.